John Gilbert is a fourth-generation farmer. He and his brother Greg raise hogs, beef cattle, and soybeans on 800 acres of land in Haugen County, Iowa.
In this era, when we have virtual this and virtual that and virtual just about everything, the land is probably one of the realest things we have. And it is really something we need to be cherishing because, quite frankly, all life on Earth depends on how well we look after our soils.
Nearly 120 miles to the east, Steve Besler and his wife Ellie Gadent own a farm near Worthington, Iowa.
I grew up on my family's farm, about 20 miles southeast of here.
It's something I've always loved. My first task as a kid was to pick eggs. And from there, we went to bottle feeding calves. We dairy farmed and raised hogs growing up. Farming's been in my blood, and it's thick as can be. So there's no getting the farming out of me.
It's safe to say that for Steve, Ellie, and the Gilbert brothers, farming is a way of life. But there's a pending court case that could impact their way of life by stripping away what many environmentalists consider to be the last guardrail against the destruction of precious wetlands. The case is CTM Holdings LLC versus USDA, and the guardrail is a provision in the U.S. Farm Bill called Swampbuster. Katie Garvey is an attorney with the Environmental Law and Policy Center in Chicago. She's intervening in this case, representing Iowa farmers.
What Swampbuster says is if you want to be eligible to receive farm benefits, you're agreeing to not drain, dredge, or fill your wetlands in order to grow crops on them.
The benefits include crop insurance, disaster relief, and USDA loans. There's a similar provision called Swampbuster that aims to preserve farmland that's been declared highly erodible and remove it from agricultural production.
If you want to be eligible for farm benefits and you have these highly erodible soils on your land, you have to agree not to farm those. So that's the history of why Swampbuster and Sodbuster were passed.
The USDA enacted Swampbuster in 1985 as a way to preserve wetlands that were quickly being plowed under or drained on farms across the country. Jim Conlon, a hedge fund manager in suburban Chicago, is challenging Swampbuster by suing the federal government. His investment firm, CTM Holdings, owns more than 1,000 acres of farmland in Iowa. The land at the center of this court case is a 72-acre parcel near the small town of Delaware, Iowa, population 140, which Conlon rents out to a local farmer. About 9 acres of that land are considered wetlands. Under the Swampbuster provision, the USDA pays Conlon in the form of subsidies for not plowing those 9 acres. Subsidies that are passed on to the farmer who rents Conlon's land. Conlon argues that the Swampbuster provision is unconstitutional.
And the reason I say that is because the federal government prohibits it from being used for anything that has any economic value at all. You can't farm it, you can't build on it, you can't clear it, take the stumps out of it, and the underlying land is probably worth $20,000 an acre. If you could, it's worth zero, it's actually worth less than zero.
But Swampbuster is purely voluntary. So why doesn't Conlon just opt out of the program?
What you could do is you could decertify that 72 acres, forego all federal government programs entirely, and then the federal government couldn't make you do anything, couldn't require you to do anything, you couldn't participate in any of those programs. That would make it difficult for a farmer to rent that land because the federal government's involvement in agriculture is pervasive. It's difficult for a farmer, a renter, for example, to operate without USDA supports.
Conlon maintains that the 9 acres of wetlands on his property are not always wet and are not connected to any other body of water. Jeffrey McCoy with the Pacific Legal Foundation is one of the attorneys representing Conlon.
The purported wetlands at issue here are completely on the property. They're not connected to any other water. They are not connected to any navigable waterway. So Congress could not directly regulate these wetlands on his property. That would exceed the Interstate Commerce Clause in the Constitution. And so instead, what Congress did was it threatens to withhold benefits that they had been awarding for decades prior to passing Swampbuster, in order to force farmers to comply with a regulation that they couldn't impose directly.
I've never met an actual real farmer that has anything good to say about the wetland laws and regulations. They despise them. I don't know who the hobby farmers are that are near there or what environmental groups they're part of. But if you interviewed 100 farmers in Iowa of various sizes, I don't think you could find one out of that typical 100 that would share that view.
But contrary to what Conlon says, there are about 2,000 farmers in Iowa and South Dakota who are fighting to save Swampbuster.
Farmers are in a very vulnerable position to be making claims of entitlement. I knew that land had wetland determinations when I bought it 2 years ago, but now I think it's unfair. That's like talking with your mouth full.
Gilbert and other farmers are concerned about increased flooding on their farms if Conlon wins and Swampbuster is overturned. Wetlands slow water down, storing floodwater and preventing it from inundating farms, homes, and riverfront towns further downstream. That's why Steve and Ellie are concerned.
We're downstream from the land in question in this lawsuit. We're about 12 miles southeast of this wetlands in question. And this is far greater than one stream and one wetland in Iowa. This directly comes down and affects us and affects our neighbors.
Katie Garvey of the Environmental Law and Policy Center says if Swampbuster is struck down, it will impact farmers and landowners nationwide.
Every acre of wetland holds 1 million gallons of water. If there's a whole bunch of water that comes and those 9 acres are gone, that's 9 million gallons of water that has to go somewhere. And where does it go? It goes downstream.
But Conlon's attorney sees it differently.
So whether Mr. Conlon succeeds or not, other farmers are not going to be hurt. They would still receive the same benefits that they receive, but those farmers that need to farm their whole property will be able to do so.
A recent study conducted by the Union of Concerned Scientists found that 30 million acres of wetlands in the upper Midwest, including the Great Lakes region, provide nearly $23 billion in annual flood mitigation for homeowners. Over the long term, the study estimates that protecting these wetlands could prevent between $323 billion and more than $700 billion in residential flood damages in the upper Midwest. Garvey says wetlands also play a vital role in mitigating water pollution.
They are the kidneys of the earth. They are providing filtration. They're removing toxins. And if a lot of those go away, there's going to be a lot more toxicity going into the Great Lakes.
But for Conlon, this case comes down to the rights of landowners.
I'm pro-environment. I'm pro-collective action, but I'm also pro-property rights, which is if you're going to take from me for the benefit of society generally, including me, you have to pay me.
I don't have any reason to doubt that the plaintiff feels genuinely and subjectively aggrieved that he's not allowed to do whatever he wants with his land and get free money from the government, but that is not a legally cognizable injury. We might call that feelings, we might call that opinions, we might call that entitlement. it's not a legal injury.
The outcome of the case could affect wetlands and waterways throughout the United States. But Garvey says that by seeking to eliminate the federal government's power to attach conditions to benefits, the case could have even broader effects.
We're all familiar with federal benefits. They all have eligibility requirements. Social Security, SNAP, Medicare, Medicaid. All of those requirements will be called into question. It would radically curtail what Congress is able to do, and it would really have an extremely negative impact on taxpayers because all of a sudden they'd be forced to be paying for programs that Congress couldn't put any eligibility requirements or any strings attached to.
For the farmers fighting to keep Swampbuster, the lawsuit hits closer to home.
Those of us who work the land, we leave footprints and shadows on the land. You know, the ethic we have, the relationship we have with the land is totally foreign to a lot of the outside people who are coming in and basically prostituting the land.
This is not an Iowan. This is someone who lives in Chicago, who has an investment property and is trying to make a change that affects Iowa farmers.
If you look at the wetlands as an endangered species, swampbusters and sodbusters is kind of the last remaining line to keep some of that wetlands in conservation.
On May 29th of this year, a federal judge ruled against CTM Holdings. Attorneys for CTM plan to appeal all the way to the U.S. Supreme Court if necessary.
Thanks for watching. Subscribe to our YouTube channel to stay up to date on the issues and changes that affect all of us who call the Great Lakes home. And if you want to support what we do, head to greatlakesnow.org to make a donation. See you out on the lakes.